So one of the comments was the canine dog certification before the apartment is rented. I certainly like that, and any type of certification, like John said, that you can put in your files is great. Because when I get calls all the time from property managers saying we have a bed bug infestation, we know we didn't put them there. They came by a tenant bringing them there. Can I charge the tenant for the treatment, not just for their unit, but all of a sudden for a major infestation where the charge is going to be in the $5,000 or $10,000 range? My response generally is, who will testify that this resident was the cause of the outbreak, that they are in fact ground zero? And a lot of the time, it's not going to be your testimony, it's going to be the testimony of your service provider, the pest management control company. And certainly if you have a good company such as the Canine Company, in addition to providing the canine dogs, I am sure that they also do other investigation and just not relying only on the dog. But if you can have a good, clean bill of health, that you have no prior complaints, that's again record keeping, that apartments on this floor had a bed bug problem, the chances are high that we will be able to make out a case to charge them the cost of all of the treatment, not just their apartment, but others as well. The problem you have, again, cost-benefit analysis, is we charge you to bring lawsuits. But it will be a lawsuit. They're not going to go ahead and pay you voluntarily. Oh yeah, here's an extra $6,000 for the bed bugs I brought here. Probably not going to happen. But how many of you, show of hands, require your tenants to have homeowners insurance? Mike Conley is going to speak next, and he's going to say, you know, we always talk about, can the person afford to pay? Those people who we require to have insurance, if we make a claim against them, we can say, turn it over to your insurer. Because there's a chance that they may be covered for your claim against the tenants for the bed bugs, or for a major mold situation if they are indeed the cause of that. So there's one statement before I start my presentation. The second one is a story I want to tell you about that's about 2 weeks old, maybe 3 weeks old now. One of my clients in Gaithersburg, right by Rio, calls me and says, we have a big problem on our hands. We have a gentleman in apartment 101 who is now claiming that he is ill because of exposure to mold. We went to his unit immediately, and we saw that the bathroom and the ceiling had collapsed into the bathroom. We saw that the water was coming from upstairs apartment, but the tenant upstairs in 201 will not let us in. Now, there are lots of facts in this case that make it even more sexy, and that is the ceiling that collapsed, it was the third time there was water in that ceiling. The fourth time it collapsed. So they knew there was a problem. So my first question, of course, is why did we keep sealing up the ceiling? That's hard to say, sealing up the ceiling, that we didn't discover where the leak was really coming from. And so I got my answer. Well, we have a letter from the doctor for the lady in 201. She has a disability under the Fair Housing Act. She is a recluse. She won't let anyone to come in. And for the last 4 years, we haven't done any maintenance in her apartment. Guys, that's not, you know, people have disabilities. It doesn't mean they get to abuse our apartments like this. So we requested to go in on each of the times he had the water leak over the last 6 months, and she refused to let us in. What did you do? Well, we figured because it was a disability, we couldn't do anything. Then when the documents come over, remember John talked about documents? They renewed her lease in October. So I said, we just tell her we need to get in. And they said, does that mean like when she stands behind the door and says you can't come in, we knock her over? I said, no, that's not what I mean. We could not get in. She could not be reasoned with. So what did we do? We're going to have a significant claim by the downstairs residents. Don't forget, her reasonable accommodation to the extent she's entitled to one doesn't mean we get to have the guy downstairs exposed to mold for 6 months and be inconvenienced with no ceiling in his bathroom. So what do? My client, after consultation with us, decided to file a temporary restraining order in the Montgomery County Circuit Court. We served it on the lady. She called frantic, no one can come in, please, no one can come in, you don't understand what it will do for me. Well, on one hand, since I'm a fair housing guy, I'm real concerned about violating her rights because she obviously has a disability and she has all the documentation. But does it mean that we don't get to do anything? The answer is no. So we went into a hearing. We made arrangements for her to attend by phone because don't forget, she doesn't leave her home. And the judge said, we are going to let them come in. I will let them come in, since it's been going on for 6 months now, within the next 10 days at their convenience and at your convenience. And she kept explaining how no one can come in, that it will simply ruin her life if she's forced to allow people in, especially people she doesn't know. Judge says, too bad. They're coming, let's pick a date and time. Now guys, me filing a TRO is not inexpensive. I think the legal bill came to about $2,600 to get all the documents evaluated, drafted, file the lawsuit, and attend just one hearing with a judge with a tenant on the phone. Compare that to the amount that they spent to replace the ceiling 3 times before this one on January 3rd, I think it was. Cost-benefit analysis, I suggest to you, that was a case that cried out for earlier intervention, and your hands are not always tied as tightly as you think they are because you're dealing with a fair housing issue in 201, a mold remediation issue in 101, and a leak that we could not fix through 101 going up to 201. It was the flange, right? You know how much the fix was, like $10. It was just the valve where it lets the water go into the toilet tank. That's all it was. Look at the amount of money spent here, and now we're still dealing with the personal injury claim for 101. And a rent escrow, but that's just a minor thing at this point. Okay, so that's one story, within the month of January that shows you how difficult this can be. And again, the quicker you react, the quicker you have advice. I really question what was going on at this property, that three ceiling repairs doesn't equate to someone higher up at the company knowing about it. With a mold situation, the mold was developing a slow drip over time. This is how it happens. And then just washing your hands of it, so to speak, we're not going to do anything. It's a very strange situation for me. Okay, any questions about that? Yes?
Yeah, if your lease, and I think most do state that we can enter the apartment for any maintenance, and it mentions that, whenever possible, you give 48 hours notice. Under those conditions, would we still have to get a temporary restraining order? Or, back in the day, I'd drill that lock off and get the work done. And I've done that on numerous occasions.
So the question is, if we have lease provisions and we have law like we do in Maryland about how and what type of notice we need to give to enter an apartment, wouldn't we use that provision to get in? The answer is sure, normally. But the situation I've described to you is not normal. She has asked for, apparently years ago, for a reasonable accommodation of no one entering her apartment. Now, had I been consulted at the time that the reasonable accommodation was made, I would have said, it's an unreasonable accommodation. While she may be disabled and is entitled to accommodation, not servicing her apartment for 4 years is not what we had in mind. So in that case, I agree with you. Had we been talking on the phone, I would say, look, if you have the personality to get in, I would not advise you to drill the locks. I'll just say that hasn't been the way we do things for many years. So I would not advise you to do that. However, in that situation, to the extent you could talk your way in, especially where it was a 30-minute repair in this situation. But short of that, guys, we should not have renewed that lease because we already knew. I told you that the water problem is occurring for 6 months. We have a renewal. A renewal of a lease takes all the prior lease defaults and throws them out the window. Okay, so you don't renew a lease for a tenant who's in default of their lease. You let them go month to month if you decide you want some hair to grow on it, some time to grow, so you don't have a retaliation case. So if you can't talk your way in, despite the fact your lease is there, I'm going to say to you, can you get in when she leaves and goes to the store? Yes, go in. I described this lady for you. She doesn't leave her apartment. Her son comes and delivers her groceries, and she hasn't left this apartment, as far as we know, in years. Follow-up question, or you're set? Okay.
Forget about the reasonable accommodation.
Yes.
Different scenario. What if we gave proper notice, we had an emergency, and we wanted to go in they didn't have a personal lock on. Could we have then just used our keys and gone in?
Okay, so the question is, if there was some type of emergency, could we have gone in if there wasn't a fair housing component? The answer to that is yes, but you need to document specifically what the emergency is. Several years ago, we had a situation where, in Crystal City, Virginia, where there was a hostage situation across the way. And someone shows up, the front desk clerk, a SWAT team, and they say they want access to the apartments on, Andy, was this yours? How about, I just remembered it was your property. All right, so the phone call comes to me, and for this, that's Archstone. Andy used to work at Archstone, so Archstone calls me for everything. It's a nice client to have. So Archstone calls over and says, we got a SWAT team who wants access to 3 units on the 11th floor. We've given no notice, but here's the circumstances. The answer is yes. You have a hostage situation. They want snipers to be able to take out the hostage takers across the way. Is that an emergency? I'm willing to deal with any tenant who would be pissed off at Archstone for doing what they did in terms of going in and allowing strangers, a SWAT team, to shoot out of their apartment into the neighboring apartment. I'm good with that. So it all depends on the facts, okay? No one got shot, right, Andy? No one got shot. They took the hostage takers out. Shot out, that's right. There was some shooting going on, but no one got shot. So it's just always interesting when I start a story and then I look out and I say, that person's here. It's a very interesting thing. So that way, he's not a plant. I haven't made this up, so I won't go to him on all my fanciful stories and say, right, Andy, didn't that happen? All right, so any questions following up on that?
I do.
Yes, ma'am.
It was a personal lock and not
Not a management lock with a key, so in what circumstance?
a leak, the ceiling fell in.
Okay. And no fair housing issue? I'm drilling their lock. First of all, your lease says, or it should say, remember these documents, John says everything turns on documents. This should all be covered in your lease. Tenant agrees that if they install a lock only with landlord's permission, they will give the key to the landlord. Now I know, folks, that people put in their own locks and don't give you keys, but depending on the circumstance, especially if they're in violation of the lease and they haven't given you a key, of course I'm drilling their locks to get in when I have a maintenance emergency. If it's an HVAC problem, and they have a lock that we don't have a key for, we're not drilling the locks. We're coming back to the management office and giving them a notice that they're in violation of the lease and we want a key, and oh, by the way, we mean it. And don't renew their lease next month until you get the key and they're back in compliance. Very practical. Yes?
That's lovely, but in affordable housing, good cause, is that really good cause to not renew a lease if they don't give you a key?
The question is, in affordable housing context, so HOC voucher situation, what is good cause to enter? And I'll put it back to you and say, what good cause would you need to enter?
No, I'm not talking about entering. I'm going to enter.
Oh, you mean to give them a notice on...
Non-renew. I have to have good cause to not.
Oh, you're talking about the end of the HAP contract where Section C says you can renew for other good cause?
Yes.
Okay, what county is your property in?
Well, they're in Baltimore City, Baltimore County, and D.C.
Okay, DC, forget about it. And
D.C., I know that. So let's talk about Baltimore City.
okay, I don't know the judges in Baltimore City as well as I should. However, Patrick May is here. Patrick is a practicing attorney here in Montgomery County. And I was surprised when he showed up because he could teach this class as well as I could. Apparently he's trying to check out the competition to see how we do it. But Patrick would tell you the same thing I would. In any of the counties where we practice mostly, certainly in Montgomery County, we have Judge Gary Everingham. Gary, what was a ground? I mean, he's not that bad. People are going, oh my God. Gary's philosophy is this. He'll say, Mr. Raftery, Mr. May, there's a 3-pronged test here. Was there a violation of the lease? Was the violation material? And does it warrant an eviction? Are you telling me, Mr. Raftery, their failure to give a key warrants the eviction of a housing choice voucher holder so that they may end up homeless? No, you're not getting possession of that case. Now, I'm willing to bet a judge in Baltimore who has not become completely jaded with the system, if they knew the law, and that's our problem, most of the judges don't know the law, would go right with Judge Everingham and say, there's no way you're getting possession of an apartment, especially from a Section 8 or HOC voucher holder, when the default that we're talking about is failure to give you a key. I would tell you, if you called me, that's not worth the money to proceed, just deal with it. And so therefore I'm violating my own rule to give notices. Sometimes notices fix behavior. We don't always have to evict on them. Now, if you have Patrick as an attorney, he'll sue everybody. I'm sorry?
If I drill the lock,
No, you're not drilling the lock. Our advice would not be to drill the lock. It's either give the note, if it's not an emergency.
in an event of emergency, if I drill the lock, I can then replace the lock with one that I have.
Sure. But I want it to be a real emergency, not a fake emergency.
No, I have
No, I'm, you know,
It's not a real emergency.
I've been doing this for about 28 years, and my clients can really concoct emergencies. Well, you know, John, that filter was due to be changed every 6 months, and it's 6 months and 1 day. It was an emergency. Okay. Any follow-up on that? You notice I haven't started my portion of the presentation yet, right?
The problem is in DC. DC is a total different situation.
It is. She says DC is completely different. Does anyone disagree with that? Go ahead.
Yeah, if you draw the lock and change, even this says it's an emergency, they can still do it.
Yeah, indeed. The question is, even if the lease says that they shouldn't have a lock, if you drill it, they can still sue you. I fully agree. The tenants in DC will sue you because they have free attorneys for almost anything. So just be aware of it. And you have to be even more diligent in DC. But please, as much as I make fun sometimes of DC and the DC courts, you still have to enforce your rights. Because if you stop doing so, the momentum will just build against you, and all of a sudden you will have a true nightmare on your hands. So while it may be frustrating, and I may tell you on the morning of trial, we have Judge Kravitz either continue the case or dismiss the case because you will not win. I know it's hard for a client to say, wait a second, should it really turn on who the judge is? Yeah. And the answer is, yes, it does. If you have Judge Kravitz sitting in landlord-tenant in DC, you as a landlord will never get an eviction even on a non-payment case. So our count, Judge Kravitz hasn't sat in landlord-tenant for 3 years. He's back in 2013. We will skip weeks that he's assigned to court because a landlord cannot get a case won in front of Judge Kravitz.
That means you have a lawyer.
That means you have to have a lawyer who knows who the judges are. That's exactly right. All right, but unless there's something really important, let me move into the presentation because lead paint is also real important. Anything else? Okay, I'm going to move through this pretty quickly because I think most of the fun stuff isn't on the board. It's the cases I can tell you about. Please be advised, if you have a building built before 1950, your building must be registered in the... I'm dealing with Maryland here. Is anyone here primarily a non-Maryland landlord? Okay, you have the Virginia property, Stacy. Where are you from? DC. So I've slandered your fine place of... Okay. DC? Virginia. So we have Virginia. Okay, so there's different regulations, different places. You know in DC, there is a DC reporting form from the mayor's office that is different from what we use everywhere else. You must use the DC form, which has additional requirements than Maryland. So I'm not going to cover it because of the makeup of the community, but if you just go to the Maryland website, the mayor's office, and type in mold form, you will get the mayor's prescribed form. You must use their form. It has additional requirements on it than most mold forms. Okay? In Virginia, it's a whole lot less regulated than what we have here because a lot of the cases that we have with the lead poisoning come out of Baltimore City, where literally there was over 10,000 cases reported in the 80s and 90s of children with lead poisoning in Baltimore City and Baltimore County because of the prevalence of the buildings built before 1950. If your building was built between 1950 and 1978, we strongly recommend that you register your building. Before the case I'm going to tell you about in a little while, you had immunity if you registered your building and you did certain testing. The immunity has now disappeared, but remember when John Scaldera was talking about avoiding litigation and record keeping? If you get sued because of a lead paint issue at your building, you would look foolish if you were standing before a jury and a good plaintiff's attorney was saying, well, even though your building was built between 50 and 78, why didn't you register it? And I would suggest to you, it's not a good idea. It costs $30 per unit per year. It's not a lot of money. It's the cost of doing business here in Maryland. Okay, any questions on that point about the timing? Okay. What we're talking about, question? No? Persons at risk. So when we know we have pregnant women or if we have children under 6, that is the lead paint area where it causes the most disabilities. We know, unlike mold, unlike bed bugs in terms of transmitting diseases, there is a direct scientific connection between the ingesting lead chips, lead dust with brain damage. It is directly scientifically proven. Very little expert testimony will be required from the plaintiff to recover against you, the landlord. This is the case I mentioned a moment ago. You'll see it has less than 2 years on it. There was a big outcry when this case came down. Prior to this case ruling this provision of the code to be unconstitutional, the most a plaintiff could recover against a landlord in Maryland for a lead poisoning case was $17,000. And most of the time, what would happen is there'd be a small amount for the injured child, $8,000. They'd give mom and dad $9,000 to find a new place to live and send them on their way. We talked earlier, and throughout today, you'll hear about cost-benefit analysis. If Ford Motor Company was willing to say it will be cheaper to pay out several millions of dollars in claims for the people that we maim and kill, you can imagine that some of the landlords said, we can probably win most of these cases, but if all it's going to cost me is $17,000 per claim, I might not clean up the the lead paint so much. So it actually became an incentive for landlords not to do what they were required to do because they had protection. Well, not surprisingly, the Maryland Court of Special Appeals came down and said, this is unconstitutional. How could we tell Maryland citizens that they could bring a lawsuit for their damages, namely having a brain-damaged child with the millions of dollars of care that would be required for that child as the child goes through his life or her life, and the landlord's only responsible $17,000? How did this come about? What's always interesting to me when you find out how things come about, there was a great concern that unless they put this protection in, that landlords would take all the buildings out of service because of the cost of the renovation. And there would be a shortage of low-income housing, the very people who are most susceptible to this type of injury. So it was like bargained for. We won't take our property out of service. You need to protect us on claims because we allow the property to be in service. And keep in mind that most people know it's just like asbestos. If the lead paint is encapsulated, namely painted over, not cracked, not chipped, it's okay. You can have asbestos any place within your home or building if it's old enough, and as long as it's encapsulated, there's not been a fire or damage to your building, there's really very little, if any, risk. But when you keep painting and painting and painting, eventually you'll get to chipping. We have a lot of dust when you have the windows sliding up and down, even though the lead paint was painted over and encapsulated, it wears away and all of a sudden you have lead dust. And that's where the cases began to come from. This case said it was unconstitutional to protect the landlords to this extent. The Baltimore Sun had an interesting article. The author's name is Timothy Wheeler. Reported that the 1994 law, when they required the testing and the protection was created, reduced the number of cases from several thousand to only 531 reported cases in 2010. While 531 or even one case is too much when you're talking about a child becoming brain damaged because of lead poisoning, it's remarkable that the estimates were in the tens of thousands back in the 70s all the way up to that low number in 2010. But as landlords, as housing providers, I hope you would agree with me that one case is too many. Okay? So if you take this seriously and again, expend the money necessary to do the proper testing, we can eradicate this and eradicate your chances of liability. Because when John talked about mold and bed bugs, we're talking about liability for lead paint. While on one hand, showing pictures of people who are bitten by bed bugs where there's no lasting health or medical issue except maybe a little bit of a scarring, as compared to having a medical doctor come in and describe the amount of care Jimmy or Johnny or Jane is going to need for the next 60 years of their life when they're functioning at a 62 IQ level because of lead poisoning. I hope you have the insurance coverage that Mike Connolly is going to talk to you about in a little bit. Okay? Questions? These are some Maryland statutes. I don't like reading them. I think they're boring, so I'm not going to ask you to read through all of them. But I want to point out to you that if you were able to get your hands on a can of lead paint, and I suggest to you that unless you are in a specialty industry, you can't, It's still available, but it has to be used in certain types of machinery and stuff like that. So you're not going to get your hands on it, I don't think, for your residential units. But if you were to put your hands on it and use it, it is punishable by a $10,000 fine just for using it in a residential setting. The code sections 815 and 819 tell you that you must do the testing, you must do inspections at every change in occupancy, and a visual check for chipping, peeling, and flaking. Again, piggybacking on what John told you earlier, a good checklist is wonderful. And I mean a good checklist that's actually being used. Not just as someone sitting in your management office saying, oh, 201 got turned over, I'm going to check all these boxes and put it away. What else do I like? Remember how horrible the pictures were of the bed bugs? How about pictures showing that there is no chipping paint, that everything is encapsulated, that the windows are opening and closing. Moreover, it's nice when you go and there is some dust on the windowsill on a changeover in an apartment. How about a picture before and a picture after the swab has been taken? Because you're going to capture the dust, you're going to treat it carefully, and you're going to send it off to a laboratory to see if there's any lead. Because if the lead is in the dust, we're going to have an abatement situation coming up. So isn't pictures of what you're doing, before and after pictures, going to be helpful to you later on if you end up being sued? The answer is obviously yes. So on one hand, if we just say, well, here we're on the witness stand, well, it's our policy and procedure to turn over every apartment and to do this testing. The plaintiff's attorney is going to say to you, who did it? Well, usually it's maintenance. Who on the maintenance staff did it in this apartment? Whoever was working that day. Who was working that day? Not sure. Can I speak to them? They don't work here anymore. Now compare that testimony to little Jimmy or Johnny or Jane, who is now brain damaged, and they've only lived in this apartment, and someone is saying, we now have lead paint, we found it, scientifically proven, and the lead paint is the cause of his brain damage. Who's winning that case? I suggest to you, the plaintiff's winning that case, and you've given your lawyers who are defending you a very, very difficult case to defend. Compare that to a checklist, filled out, completed, person's name on it, with pictures showing what they were doing as they entered and walked around the house, show the swabs being taken, showing that there is no chipping paint. What a wonderful thing to go with the checklist and later on, because then we're going to try to suggest that while the child does have lead-caused brain damage, it's not from us. It's not from us. It's from some other environment where he may have been in. Frequently, one of my clients down in DC does have a contaminated building, and they got sued, and what Dad said was, my son has lead poisoning and it's caused from visiting here. In the discovery of the case, it turns out he only has visitation. The children were in the apartment, as far as we know, in the 1 year he lived there, 6 times. It cost a lot of money in investigation to find out where else this kid was, because there's no doubt he has lead-caused brain damage. The investigator found out that even though Mom wasn't telling anybody, Mom had a boyfriend. And even though Mom was supposed to be living with the son in the apartment where she lived, she visited her boyfriend and brought her son with him. Guess what was in the boyfriend's apartment? Well, Dad was pissed off because he knew we had lead paint and it must be the cause of the brain damage in his child. It's only because we've tracked Mom to find out that the child was really spending 13 out of every 14 days in the other apartment with lead paint, and 1 out of 14 at most in our apartment. Guess who didn't have to pay any money on that case? Okay? So good record keeping is the way you want to go. It's nice to see 98% reduction, but we can make it 100. Okay, so this language comes out, MDE, by the way, Maryland Department of the Environment. So excellent website, great forms, the forms that John talked about from NAA, all the forms that you might want to use, and I left many of them on the table for you this morning. Hopefully there were enough. It tells you that despite the fact that the elimination of the $17,000 cap, we suggest that you opt into this program. You have to register, you have to test, you have to do risk reduction activity, and then the remediation when it is determined that there is lead there. The Act was amended in 2011. New provisions were effective as of January 1 of last year. Requires testing of lead dust of all affected properties prior to occupancy on each turn of the apartment. Someone came up during the break. Joe, do you mind if I pick on you for a second? Can you give an estimate of what it costs to do the swab testing at a laboratory, approximately?
Well, the per sample cost is probably on the order of about $25 per sample, but if you have a consultant come out, then there's labor fees involved with that and travel and so on.
All right, and Joe, if you don't mind, can you stand up? Joe introduced himself at the break. He is with a company that provides this. I haven't used this company before, but we're going to talk offline because it does seem to know that Joe knows what he's doing based on our little discussion, and that's why I pointed Joe out. So if you're talking about your people being trained, the certification is not hard to get. So your maintenance staff can be trained if you're willing to train them, and the sample they're sending off is only $25. It's a cost of doing business that's not exorbitant. I'm sure Joe's people charge a little bit more than that if he sends his people out, but this is the type of thing that you're now required to do. Okay? When a child is reported with the elevated blood levels, we have 9 treatments and visual inspections. And again, that's on the website. You can keep records of each of the 9 treatments. You want to make sure that the people are coming out are actually doing the work. And this is where if you're going to certify your own people to do it, which you can do, including in DC, to make sure they're trained well and the documents that you're doing, showing the treatments, what was done, and pictures are taken. That is the way you can protect yourself when the lead level doesn't go down and the lawsuit is brought later on. Remember, this is testing. If a child goes into a pediatrician and shows any of the symptoms of lead testing, they will test the blood. It's a normal test. That's how it's found, and it's found immediately. And then they start looking as to how it got there, and that's when, if the injuries are significant, we're going to have lawsuits. The interesting thing in the District of Columbia, which you may recall from watching the news, there was lead in the water. So I have not yet had a case where we defended by saying it wasn't our apartment, it was the water that was being consumed by the child because the DC wasn't keeping track of the amount of lead in the water. Okay? Those are the type of nasty things that defense attorneys do. They point the finger. We've never done that, have you, Patrick? Never. Okay. Yes. I'm sorry, question.
I have a question. So you do it at term, which is what we do at my property, but how is that accounting for any lead exposure that may happen in between the time that they first move in and when they eventually move out?
Okay. I agree with John fully on this. If you have the lead forms that you're putting into your lease and having a new tenant move in, you're telling them to alert you when there's a chip, when there's dust, when there's anything like that. Moreover, if your on-site people, the maintenance people are trained, they know what to look for, that when they're going in for the simple changing of a faucet or unclogging the disposal or the toilet, I'd like them to be looking around. Then is the time, if you have a minor chip or a problem, to do the abatement in a limited area before you have to do a major one.
So ours is in the glass.
Is in the glass.
So they have to vacuum the window and sample. So
Leaded glass.
It's invisible.
It's invisible.
It's basically invisible till they swap
Okay.
the time if it's there.
I'm sure you guys have done the cost-benefit analysis. When there's lead present like that, you need to do a window replacement, as early as the property can afford to do it in the capital improvement. Short of that,
1912, the Historical Society will not.
1912 historic building, they won't let them change the windows. Isn't that fabulous? So you have lead paint, and then we have aesthetics, and we're going with aesthetics over brain damage. Fabulous. But in any event, that just shows you a little politically where I am on historic buildings. But on this situation, what you got to do is I would recommend that you do yearly testing, even if the tenant doesn't move out.
So we could do sampling during preventative maintenance.
Sure. And I want to be careful here. You don't need to be as worried about it when there's not a pregnant woman or children under 6 in the building or in the apartment. However, we don't know who's coming to the building, and we shouldn't be following our tenants around. For example, if I move into your building with my wife, and if my oldest daughter ever has any grandchildren, it's never going to happen, guys. I hope you feel bad for me. There's not going to be any grandchildren. But my grandchildren can come visit me, and you have no way of knowing that, so you think you could ignore my apartment because I'm going to live there until I die. But in reality, I've got 2 or 3 grandkids running around there frequently. You need to be concerned. So as part of your maintenance, whatever you do, especially if your people are trained, Go by, take a couple swabs. It's not very intrusive. Spend the $25 to get it tested. Then you know that you're safe. Good record keeping. You're going to be able to fight that claim if my grandkids come down with some lead poisoning and brain damage as a result. All right, did everyone understand the question and the answer? Okay. I have too many things in my hand. We're talking about Maryland law, which is basically enforced by MDE, Maryland Department of Environment. You have to be aware that the EPA also has restrictions on all this type of stuff. So as John said earlier, not surprisingly, we need to look at federal, state, and local law because some of the localities have more stringent requirements than MDE. Okay, especially in Baltimore City, where you're may have some additional requirements in addition to the one I told you about. All right, so basically the same checklist as John shared with you earlier. If you get notification, and you will receive it officially from the county or from the state or from the District of Columbia, if that's where you are, that you have an EBL, it is your first notification that you have a problem. I'm hoping that you would have known what was going on at your property as you appear to do already, that you already know you have this problem, you're trying to do the best you can with it. When this notice arrives, you better start making sure that you gather your files together, okay? So we want to make sure that we have all the information for that one and all the other apartments around there where there may be a similar problem. We want to retain and secure all leases and information for prior residents. There's a doctrine that us lawyers deal with sometimes, and it's called spoliation. It's basically when a defendant in a case kind of doesn't keep all the records that may help the plaintiff figure out that we haven't done our jobs. And so there can be a presumption in the law that when the defendant who's being sued hasn't retained the records to show that the plaintiff or that the landlord knew or should have known that there was a problem, it can be held against you in the court of law. It's a bad presumption to get. In the federal courts nowadays, when you file a lawsuit, one of the first things the court enters is a directive that no documents should be disposed of, and it specifically tells you that if the documents are later found to be missing, it will be presumed that you destroyed them and you can be held in contempt. Bad finding if you're trying to win a case if you're already being held in contempt before the jury hears the case. So start doing this. And you may want to hire someone else on the outside to do it for you. There are companies that do this, that will come in and forensically begin gathering information. And oh, by the way, we're talking about computers as well. We're talking about all the emails that may have been sent, all of the email communications, phone messages if they're recorded. All of this stuff is discoverable. The time to do it is when you find out about the notice, not when the lawsuit arrives. Because a year or two may go by and you really need the stuff that you threw away just last month because you didn't know there was a lawsuit. That's the trigger when you need to start being proactive. Retain and secure testing, abatement, registration data. There's nothing worse than having a client come to you and say, you know, we had it in the basement and it all got flooded and we threw it away. Well, it's the same as not having it. And unless the company's still in business and you can get another copy of it, it's going to be presumed there was something in there negative to you. The fourth bullet, Mike's going to talk about that. Even if you don't think you have coverage, the first time you're notified of the possibility of a claim, which is the notice, you've got to notify your insurer so you don't create a possibility of your insurer saying, it was a late notification of claim, we're not providing coverage. Contact your attorney. If you've not dealt with this before, we can walk you through what you need to begin doing. Certainly give you some advice to get you in the right direction. The other point about contacting your attorney early on, especially whether it be mold, bed bugs, or lead paint, but in mold and bed bugs, it's more likely you're going to do something to make it up for the tenants. So let's send them a gift card to make up for the difficulties they had or the fact they had to move out of their place for a day or two. If you're taking money out of your pocket, or if you're forgiving some of the money that the tenant owes you, as most of my clients do, and I recommend it's not a bad idea when you can make a tenant happy at the outset before lawyers are involved, document it. I have releases that I give to my clients that don't sound like a lawyer wrote them, but they would still be enforced in court. So if you're going to give away $500, I frequently say to clients, well, you gave away $500 in a gift card, what did you get back besides the thank you? Because you now have a lawsuit anyway. You could have had $500 in your pocket, and many times early on, not that we're trying to trick people, but if we're going to be giving them free dry cleaning of all their clothes, and we're going to be giving them some other inconvenience money, why not get a release at that point for the claims, because that release will be held up later on. There's one caveat I want to tell you. On lead paint, we're talking about children being injured. Please keep in mind when you have children, parents cannot release claims by their children without court supervision. Let me restate that. If we have a child and they're injured, whether it be from mold, bed bugs, or from lead paint, and we sneakily go in and tell the parents, hey, look, we'll give you $10,000. We want you to sign a release because of you and your husband and for your son. A lot of people, $10,000 is a lot of money. When the case is really worth hundreds of thousands of dollars or $1 million. That release from mom and dad will be valid as to them as adults. It does not release the claim of the child. You need a court order to settle claims, personal injury claims for children. And it's a good law. You can see why, because lots of moms and dads sometimes will take the money and then they don't realize that that kid is going to need medical services for the next 60 years of the kid's life, and there's no money, and they become a warder of the state. Okay? Advice from your attorney. Yes, so you get advice from your attorney regarding communicating with the parents of the child. You don't know how many times I see an email, we are so sorry that this happened, or else I have the following come out in the case. Well, the maintenance guy said, we have mold throughout this property. If only the landlord would fix the downspouts, we wouldn't be having this water. You get your people saying all kinds of crazy, stupid things, and we don't need that to occur. All right, so again, a little bit of education, making sure your staff isn't out there killing you with their own statements about what's going on. My other favorite thing when I deal mold cases, I've never had a mold case where it wasn't toxic, deadly mold. Really, it's just mildew that they didn't clean off their shower. But all the cases when the emails go is always toxic, deadly mold. Or how about this one? There was a flood in my apartment. I really dislike when you guys repeat the tenant's assertion in your incident report. Inspection done, flood in the apartment. When I think of flood, guys, I'm thinking of 2 feet of water. I'm not talking about a 4 or 5 foot area that got wet. So be careful when you're doing an incident report, which is one of your records we're going to look at. Let's not just adopt what the tenant says. So the tenant didn't have a flood, the tenant had a leak. There was staining. You don't say there was mold. And you certainly don't adopt the toxic mold, even though we use that in our outline to make it more sexy. At the end of the day, we don't know if it's mildew, black mold, or any of the nasty stuff that John put up that I can't pronounce. That's why we have a laboratory test done. And just on that, I have had cases where the client tells me, oh yeah, we did a test. We sent it off, and so we'll send you the results as soon as it comes in. The plaintiff's got a test, and I find out that the test never measured outdoor versus indoor. While we may look down and say, geez, there's a lot of mold in this apartment, it's really not the bad mold, but there seems to be a lot of it. It wins every time when we have a good laboratory analysis that shows the amount of mold indoors is 30% of what it is on the outdoors, especially when it's a water intrusion case. If it's really wet and that foundation or that wall is leaking for the first time in 6 years, and we've got some mold developing, chances are when the study is done inside, especially after we fix the problem, the concentrations are going to be less than what's outside because all that water that came in is out in the grass and on the leaves and everything's decaying. And when things decay, it's food, and there's your mold spores that are going to be airborne. So most of the mold cases we handled, I would say a significant number of them go away when we have a reputable laboratory that shows that the inside concentration was less than the outside concentration. So basically, I get very sarcastic sometimes if there's not a jury present, and I say, Your Honor, the plaintiff should thank us for not putting them outside where they were able to walk around and breathe the clean air, because our air inside was cleaner than it was outside. Because it really does help minimize the claim. How can you claim that you're ill because of the air in your apartment where when they walked back and forth to work, they were exposed to a greater concentration of mold? It's what John said, the causation issue. Now you have to prove to me that the mold at lower concentrations in my apartment is what making you sick, as opposed to you walking back and forth to your car and being out with your kids walking in the park at higher concentrations. It breaks the causation requirement in all successful litigation. You may want to consider temporarily moving when you do have that bad mold situation. And always retain a qualified certified professional to test and abate the apartment. You win cases based on someone coming in, describing to basically an ignorant judge what mold is, that these molds that we're seeing with these fancy long names aren't toxic, they don't cause illness, and this is the methodology we used, this is how we tested, this is what we found, and what looks to you and me to be bad because there are, I'm making this stuff up now, 8,000 parts per meter?
Spore counts per cubic meter.
Cubic meter, spore counts per cubic meter. That sounds horrible until you see absolutely no big deal, and when the good lab reports come in, it will show you that it is well within the acceptable levels. Okay. Okay, this is you now, right, Mike? All right, so because we're going to change microphones ever so quickly, we have to take another 1-minute break. We're going to take you right to 12 noon. We're going to answer all your questions, I hope, and Mike is going to bring us home from here. Thank you very much for being a wonderful audience.